Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at Guru Govind Singh Indraprastha University, Delhi, Dwarka. Today we will talk about Labour and Industrial Law 1, into which I am going to take lecture number 8, which is on Payment of Wages Act 1936. So this act is very important, because when we talk about this act, before the passing of this act, the condition of workers were very bad, because employer, they were not bothered about the wages of their employees, and the untimely wages had to be given to the workers, that and unlawful deductions they used to make it from the wages. They were not bothered on which date the wages has to be given to their workers. So just to eradicate these kind of the problems, or just to remove these evils from the society, it had been realized that there is a need to have some any kind of the legislative measures by which the protection can be given and the timely payment can be given to the workers. So with this intention, one of the private bill came into the existence. The name of this bill was the weekly payment of the bill, because the purpose of this, and it was put up into the legislative assembly in 1925, and with this intention, just to remove all these difficulties, so workers they can get their timely payment of the wages, unlawful deduction can be removed, and delay can be avoided, and untimely everything can be taken care of through the passing of this bill. But the government gave the assurance that not to pass this bill, rather they gave the assurance we would be coming up with the good legislation to take care of all these reasons. So the Payment of Wages Act 1936 was passed with this intention to give the protection to the workers. So when we talk about this act, into this, a royal commission at that time, they gave the recommendations for the protection of the workers, and whatever the recommendations has been given by the royal commission at that time, they have been well taken into the consideration, and they have taken into this Payment of Wages Act. So these the recommendations which has been given by the royal commission at that time was, number 1, that is, children should be exempt from the fine. The sum realized as a fine should be utilized for some purpose beneficial to the employees as a class, or should be approved by some recognized authority. A notice specifying the act or the omission in respect of which the fine may be imposed should be posted, and any other fine should be deemed to be illegal. Any deduction made for the goods having been damaged should not exceed the wholesale price of the goods damaged. Deductions may be made on account of the provisions for the housing accommodations and the tools and the raw materials. Imposition of any fine or the deductions made which is not permitted by the law should be made penal. So the Royal Commission gave the recommendation, number 1, the child should be exempted from any kind of the fines or the deductions. The second is, whatsoever the deduction is made by the employer at that time, they should be utilized for the welfare of the labor. They must have to mention that what kind of the act or the omissions would amount to the misconduct. They must have to notify it, and that is say for example, because they had the system of the fines and the deductions, so they must have to mention the grounds on where the fine can be imposed, and say for example, if there is the damage of the property has been caused, then to what extent the person would be liable to give the compensation for that, and if the employer is making the unnecessary deduction for this, the penalty can be imposed. When we are talking about the object of this act is, this act is having the two folds. This is, number 1 is to give the timely payment of the wages to their workers, and second is to give the second is unlawful deductions can be avoided through this act. When we talk about to ensure the payment of the wages to the persons covered by the act, certain provisions has been made under this act. In a case, Bombay High Court in Arvind Mills Limited versus K.R. Gadgil observed that the general purpose of this act is to provide that the employed person should be paid their wages on a time, and that is in a particular form and at a regular intervals without any unauthorized deductions. And here we are using the term certain classes of the persons in the preamble, which is very important for the act applies to the persons drawing on average wages less than the 1000 rupees a month. When we are talking about this act is applicable all over India, and the categories has been mentioned where this act would be applicable. It applies in the first instance to the payment of the wages to the persons employed in any factory, persons employed upon a railway by a railway or through any contractor, or it can be by the administration directly or indirectly through the contractor, and a persons employed in any industrial or the other establishments. When we talk about the definition of the industrial establishment or other establishment, it means tramway services, motor transport service, engaged in carrying passenger or good or both by the road or for hire or reward, air transport service other than such services belonging to or exclusively employed in the military, naval and the air force of the union or the civil aviation department of the government of India, dock, wharf or jetty, inland vessel mechanically propelled, mine, quarry or oil field, plantation, workshop or other establishment in which articles are produced, adapted or manufactured with a view to their use, transport or sale, establishment in which any work relating to the construction, development or maintenance of the buildings, roads, bridges or canals, etc. relating to the operation connected with the navigation, irrigation, etc. Any other establishment or class of establishment which appropriate government may, having regard to the nature thereof, the need of the protection of the persons employed therein and other relevant circumstances specified by notification in a official gazette. So, this act would be applicable. It applies to the persons which are covered under the industrial establishment. When this act came into the existence, at that time it had been realized that this would be applicable those who are getting a particular salary. Later on this limit has been increased and the threshold has been made, that is it would be applicable those who are getting the salary not above the 6,500 rupees. And later on when we see the condition currently, it had been amended in 2017 where this limit has been fixed. Those who are getting the salary up to the 18,000, they would be protected under the Payment of Wages Act. When we talk about important definitions, we are having there a few important definitions, that is appropriate government establishments or certain class of the establishment where this act would be applicable. Already we have covered it. Now we are talking about the definition of the wages. See, into this act, as we discussed earlier into the other acts, the definition is not uniform. The same is the case with the Payment of the Wages Act. Here the definition of the wages is given, and which would be included into the definition of the wages, which will not be included into the definition of the wages is as follow. Wages means all remunerations, includes remuneration under any award, overtime payment, additional remuneration, sum on termination, sum to which the employee is entitled, because into which it means remuneration means when we complete any kind of the act, later on we will get the remuneration of that. So, into this act we are talking about overtime rate, it is a part of the wages, and the other things which they have not been covered under the different legislations. So, we have included the few points, few things which are the part of the wages here under this act. but does not include into the category of the wages is any bonus not in terms of the employment, value of any house accommodation, any contribution paid by the employer to any pension or the provident fund, some paid to the employed person to defray special expenses, any gratuity other than the mandatory under the law. The bonus is which is not in terms of the employment, which is not related with the employment, is not included if if the employer has provided any house accommodation, it will not be considered to be the part of the wages. Any contribution which has been paid by the employer for any pension or any PF provident fund, it will not be part of the wages. Or if any kind of the sum has been paid by the for the special expenses, then that is also not considered to be the part of the wages. Or for the gratuity which is mandatory by the law, that is not the part of the wages. So we are having the definition where we have made this segregation which is considered to be the part of the wages and which is not considered to be the part of the wages. Next is responsibility for payment of the wages. When we are talking about responsibility of the payment of the wages is of the employer. See, employer is if it is a case of the factory, into the factory the manager is there who would be responsible to make the payment of the wages to their workers. If it is a case of the industrial and the other establishments where the person who is having the supervision and the control over the affairs of the that establishment would be considered to be the employer. If it is a case of the railway, the person nominated, contractor, if the contractor is an employer whom the contractor would be designated, would be responsible, would be considered to be the employer. And in any other case, after that section 4 is talking about fixation of the wage periods. This is very important because just to make the compliance of the wage period, whom we would be saying the wage period is, because say for example, if someone is doing the work for a month, after completion of the month, that period is considered to be the wage period. Normally, say today is the 20th March and this is the duty of the employer, they must have to for the wage period is 20th April would be the wage period. It means once the person would be completing this month would be considered to be the wage period. But here which is very important point is every employer responsible for the payment of the wage under the section 3 shall fix period in respect of which the wages shall be payable. No wage period shall exceed 1 month. Section 5 is talking about the time for the payment of the wages, because the wage period is important. Wage period means completion of 1 month, it cannot be more than 1 month. But when we are talking about time period for the payment of the wages is the wages of every person employed upon or in any railway, factory or industrial or the other establishments upon or in which less than 1000 persons are employed shall be paid before the expiry of the 7th day. So, it means we are talking about, that is, if it is a case of the railway, factory or industrial establishments, their wage period would be before the expiry of the 7th day. It means 1 month is a wage period, but this is duty of the employer is they would be giving the wages to their workers before the expiry of the 7th day of the next month. It means 37th day after completion of the 1 month plus before the completion of this 7 days. So, that is the considered to be the time for the making the payment to the workers in this category. And the second is any other railway, factory or the industrial or the other establishment shall be paid before the expiry of the 10th day. So, if it is a case of the other railway, factory or the other establishment, the wage period would be before the expiry of the 10th day. And we are having the exception to this, where this time period of the time of the payment of the wages will not be applicable in that way. Exceptions are in case of the dock, wharf or the jetty, before the expiry of the 7th day of the date of the completion of the work, because into the case of the dock workers wharf or the jetty, because normally wages means remuneration. It means the wages would be given to the workers once they would be completing their work. But normally when we talk about the dock workers, they are doing the kind of the loading and the unloading work or the other work. So they would be entitled to get their wages once this work would be finished. So they would be entitled once the work would be completed and before the expiry of the 7th day of the completion of that work. And in case of the termination of the work, due to the closure of the establishment. So this is again a exceptions. If any of the establishment has been closed, that is the wage time for the wage period would be before the expiry of the 2nd day. So say for example, today 20th of March, that is someone has closed down the industry, closure of the industry. So before the expiry of the 22nd of the March, this is the duty of the employer to make the payment of the wages to the workers. So this is the duty. And next is Section 5 clause 4, it talks about wages to be paid on a working day, because it is very important that the wages has to be paid on a working day. Otherwise into the other act we are not talking about, but here we are dealing with the timely payment of the wages. So timely payment, it talks about the working day as well. So it is a duty of the employer, they must have to make the payment on a working day, not on a Saturday, Sunday or any other holiday. Next is mode of payment of the wages. So when we talk about mode of payment of the wages, we are having the different ways how the wages can be given. When we are talking about in payment, in Minimum Wages Act, we were talking about the wages can be paid into the, it can be in currency coins, it can be, in kinds. So, but here we are not considering the kind of thing. Here we are talking about, we are having the different modes for the making the payment of the wages. Number one is currency coins, or that is a coins can be given, or currency notes can be given, or through the check it can be done, or crediting into the bank account. So either the check is the appropriate way, or crediting into the bank account is, again we are talking about the digitalizations, and just to make it ensure that the wages would be received by the workers only, that's why we are having, the government has made the amendment and they have added in 2017 this provision, that is the wages can be wages can be credited into the account of the worker. So and normally when we notice that if we are talking about either the the government employees, normally they not normally, but they receive their salaries or the wages into their accounts or through the check. No currency coins or the no notes would be given to the workers. So this is the practice. And when we are talking about a daily payment of the wages, so this kind of the decision can be taken with the consultation of the appropriate government, because when we talk about these things, appropriate government is the ultimate authority who would be deciding this matter. Section 7 is talking about deductions which may be made from the wages. At the time of the payment of the wage to employees, workers should make deductions according to the act only. Employer should not make the deduction as he like. Every amount paid by the employee to his employer is called the deductions, because when we talk about deductions, so this is the second reason for passing of this act is because earlier the employer they used to deduct the wages because of any other reasons. That was normally the unauthorized deduction, the trend was there. Or sometime for the overtime work, if the someone is not coming on a duty, the double wages used to be deducted of the workers. So just to address this kind of the problem is only the permissible deduction which is law permit, the employer can go for the deduction for that only, but otherwise the rest is not allowed. So when we talk about, so the following are not called the deductions. If the stoppage of the increment of the employee, that is not the deduction, because Increment is the right of any of the employee, but if the employer is not making the deduction, not giving the due of the increment to the employee, that is not the deduction. Stoppage of the promotion of the employee, stoppage of the incentive, lack of the performance of the employee, demotion of the employee, suspension of the employee. So, the above actions taken by the employer should have a sufficient reasons. So, if the employer is going for these kind of the practices, not giving the increment, timely increment which is due, or making the demotion of any of the employee, so this is not allowed. If someone is going for these kind of the practices, employer, they must have to give the reason for this. In section clause 2, deductions has been given, and we are having the so many section which deals with the deductions, but when we talk about this section is, a deduction made by the employer should be made in accordance with the act only. The following are said to be the deductions and which are acceptable according to this act. So, when we are talking about the fines, then in that case maximum 3% of the wages per month. See, when we are talking about the deductions, we are having the different grounds when the deductions can be made. If we are talking about the deductions, and that is for the fine is, that is for a monthly, from the monthly wages, only the 3% is allowed. Say for example, if the person is getting their wages, or that is a say for example 20,000 per month the person is getting the wages, then in that case only the 3% would be allowed for the deduction, in that is for the fine. It means that is 600 rupees can be deducted from the wages, in that is in through the fines only, not more beyond that. If it is a case of deduction for the absence from the duty, deduction for the damage to or loss of the goods made by the employee due to his negligence, deductions for the house accommodation supplied by the employer or by the government or any house board, deduction for such amenities and the services supplied by the employer as the state government or any other officer. See, we are having the different grounds for the deduction. As we discussed, the fine is there. If someone is not coming, not reporting to a duty, and it is a case absence from the duty, means there should be the person is not having the interest, he don't want to come to the industry on that day, he is not into that mood, he want to go with the family, he want to enjoy, he want to sleep. So, that is the absence from the duty. That doesn't mean the employer has told him, okay, whenever I would be having the work, I will inform you, then you can come at that time. That is not the absence from the duty. But if someone is willingly does not want to come on a duty on that particular day, that would be considered to be the absence from the duty. And if any kind of, say, if the person is enjoying the house accommodation which has been provided by the employer, or because of the any kind of the housing policy, but the worker is enjoying it, so he has to pay for that. And we are if the person is taking the benefit of these things, so these are the ground for the permissible deductions. Deductions required to be made by the order of the court or other authority competent to make such order. Deductions for the subscriptions to and for the repayment of the advances from any provident fund. Deductions made with the written authorization of the employed persons or the president or the secretary of a registered trade union. Deductions for the payment to the cooperative societies approved by the appropriate government or any other officer specified by it in this behalf, or to the scheme of the insurance maintained by the Indian Post Office. So, when we talk about these deductions, if any kind of the order has been given by the court, deductions can be made. Either someone is making the for the subscription or for the repayment of the advances which has been taken it from the provident fund, then in that case deduction can be done. When we are talking about the provident fund, because this is not allowed to withdraw the money, but the thing is we are having the different grounds. If someone needs for the they want to withdraw from this fund is PF, that is, say if the person need it for the marriage of of any of the child, or for the construction of the their home, for the repairment. So we are having the grounds, but that doesn't mean he has to repay back. So for this purpose the deduction can be made from this from the wages of the workers. And deduction for the payment of the cooperative society. When we are talking about the deduction for the payment of the cooperative society, for this a 75% of the deduction can be made. It means because this is the highest deduction. If someone has spent into the cooperative society, and if the employer feels so, that is the employer would be managing his family and he wants to deduct from the wages for the 75% of the salary, he can do so. Say for example, if someone is having the salary, is getting the salary that is say 75% is permissible. Say for example, if someone is having the total salary is per month 10,000. If someone is drawing the salary 10,000 per month and they want to deduct it 75% from the salary for the cooperative society, it means 7,500 can be deducted from the wages of the workers. So it is permissible. Deductions for the payment to a scheme of insurance maintained by the Indian Post Office. Deductions made if any payment of any premium or premium on his life insurance policy to the life insurance corporation with the acceptance of the employee. Deductions made if any contribution made as fund to the trade union with the acceptance of the employee. Deduction for the payment of the insurance or any kind of the guarantee bond with the acceptance of the employee. They can go for these kind of the deductions. Deduction for the recovery of the losses sustained by railway administration on account of the acceptance by the employee of fake currency. Deduction for the recovery of the losses sustained by railway administration on account of the failure by the employee in collection of the fares or the charges. Deductions made if any contribution to the Prime Minister's National Relief Fund with the acceptance of the employee. Deduction for the contribution to any insurance scheme framed by the central government for the benefit of the employees with the acceptance of the employee. Because if someone is, these are the permissible grounds. If any of the workmen is by chance receive the fake salary at the time of discharge, giving the ticket, so at the time of giving the ticket, who would be responsible then? Because the railway administration cannot take the responsibility if they are not discharging the duty very well. Or otherwise, if the person is collecting it for the Prime Minister's National Relief Fund, already we have seen all these things at the time of the COVID, or in case of the natural calamities, because whenever the need is, any of the employee, they give their consent and the employee, they can go for these kind of the deductions. So they come under the category of the permissible deductions, where the employee is not having any problem and they are the very genuine. Section 7 clause 3, it talks about that is a limit for the deductions. So the total amount of the deductions from the wages of the employees should not exceed 50%. But only in case of the payments to the cooperative society, deduction from the wages of the employee can be made up to the 75%. So otherwise, this is normal practice is limit, yes, 100% deduction cannot be made. So maximum deduction is permissible under this act is, that is a 50%. Only in case of the cooperative society, 75% deduction is permissible. Next is fines. If the fines are imposed by the employer on an employee with the approval of the state government or prescribed authority, the employer should follow the rules mentioned and before imposing any of the fine on the fines on the employees. For this, the notice board of the fines on the employee should be displayed in our work premises and it should contain the activities that should not to be made by the employee. Fine should not to be imposed on the employee until he gives the explanation and the cause for the act or the omission he made, because the principle of the natural justice has to follow and he must have to give the reason for this. And total amount of the fine should not exceed the 3% of his wages. Fine should not to be imposed on any of the employee who is under the age of 15 years, because if we are having a child or who is below the age of 15 years, he cannot be accountable for any kind of the fine. And but if it is a case of the fine, only the limit has been fixed, that is a 3%. That is, if the someone is getting the salary that is 10,000 per month, then 3% would be the 300 of it. So 300 rupees can be imposed, that can be deducted from the wages of the monthly wages of the workman in that case. And fine should be imposed for one time only on a wage of the employee for the act or the omission he made. Fine should not to be recovered in any way of the installments from the employee. Fine should be recovered within a 16 days from the date on which the fine were imposed. Fine should be imposed on a day act or the omission made by the employee. All fines collected from the employee should be credited to the common fund and utilized for the benefit of the employees, because if they have deducted, if they collected this money through the fines, this kind of the money has to be deposited into one of the place, and this money has to be utilized for the welfare of the workers. Deduction from the absence of the duty. Already we have discussed it. If the someone is willfully not coming for the duty, would be the salary can be deducted for this reason. Deduction for damage or the loss. Deduction for the services rendered. Deductions for the recovery of the advances. If the someone has taken the advance from the government, that is, this is the duty of the worker is, for this the deductions can be made. And say for example, if the someone has taken for the house building or the other purposes which is subject to any rules which has been made by the state government, then and it has to be very mentioned that how much the loan would be granted and the rate of the interest payable thereon for this. So the thing they must have to mention it very clearly. Deduction for the payment to the cooperative society and the insurance schemes. So if the someone has taken any kind of the insurance schemes, then the deduction can be made, and for this cooperative society, as we discussed, up to the 75% of the deductions can be made. Now the next is very important, maintenance of the registers and the records. Every employer should maintain such registers and the records, giving such particulars of the persons employed by him, the work performed by them, the wages paid to them, the deductions made from their wages, the receipt given by them, and such other particulars, and in such form as may be prescribed. Every register and the record required to be maintained and preserved for a period of 3 years after the date of the last entry made therein. It means for every transactions made therein, made within this register by the employer and the employee, and they must have to, this is the duty of the employer, is they must have to maintain the record for the 3 years, because this register is very important, because at the time might be anyone, if any inspector or any authority, they come for the inspection, they can check this register. So this is the utmost responsibility of the employer, is they must have to maintain each and every record into that registers. When the deduction has been made, name of the employee against whom the deduction has been made, or relating to it, every kind of the record has to be maintained, and this is the duty of the person, is of the employer, is they should not throw the register, they must have to maintain it, and they must have to keep it in a proper condition for the next 3 years. Section 14 is talking about the inspectors. So whom we would be saying the inspector is the state government may appoint the inspector, and inspector is a public servant. A public servant definition has been given in Indian Penal Code 1860, and this inspector is having the powers. Inspector can make inquiry and the examination whether the employees are properly obeying the rules or not. This is the duty of the inspector only. They would be checking each and everything, and the inspector with such assistance, if any, as he thinks fit, enter, inspect and search any premises of any railway, factory or the industrial or other establishments at any reasonable time for the purpose of carrying out the object of this act. So, this is the duty of the inspector is, because the inspector is, as we are discussing, that is appropriate government is would be appointing the inspector, and inspector is a public servant. So, all the authority has been given to the inspector. Whatever I mean, if the person wants to, if the inspector wants to see the record, he can see the record, he can examine the witnesses, because the inspector is discharging the responsibility. So, if the inspector thinks so, with the help of the assistant, they can enter into any kind of the premises. If they want to visit any of the premises, they feel so there is a need or some suspicion is there, they can enter along with the agent, but it is a condition that is they would be taking care of the privacy of any of the employer. So, they must have to visit within a reasonable hour into that premises. Inspector can supervise the payment of the wages to the persons employed upon any railway or in factory or industrial or the other establishment. Seize or take the copies of such a registers or the documents or portions thereof as he may consider relevant in respect of an offence under this act, which he has a reason to believe he has been committed by an employer. So, if the inspector is having any kind of the doubt, that is his call. He can seize all the documents which are very important for the making the inquiry or making the investigation. So, he can take all these documents into the positions. Next is section 14A. It talks about facilities to be afforded to the inspector. Every employer shall afford an inspector all the reasonable facilities for making such entry, inspection, supervision, examination or inquiry under this act. So, this is the duty of this inspector is they must have to facilitate the inspector, so there won't be any kind of the problem, and they must have to give all these helps, I mean, he can make the entry into the premises, they must have to provide the documents, and if they want to go for the examination, want to make the inquiry, so this is the job of the employer, they must have to facilitate. In section 15, again it is very important, claims arising out of the deductions from the wages or delay in the payment of the wages and penalty for the malicious or the vexatious claims. So, for the claims that is arising out of the deductions, because it means we are saying ki already that is the deductions has been made. So, now we are before the employee is or worker is before the authority, the person wants to claim the wages which has been deducted by the employer. So, who may be appointed for this? The appropriate government may by notification in official gazette appoint any commissioner for the workmen compensation or any officer of the central government exercising functions as regional labour commissioner, assistant labour commissioner with at least 2 years experience or any officer of the state government not below the rank of the assistant labour commissioner with at least 2 years experience. So, these persons can be they can be appointed by the appropriate government. Appropriate government can give they can notify into their official gazette and they can appoint these authorities for the these authorities they would be deciding the claims. For this, that is commissioner for the workmen compensation, because we know that there is we are having the commissioner is there for the deciding the under the Workmen Compensation Act 1923, where we were talking about where the commissioner used to deal with the matter which is related with the that is in case of any kind of the injury, accident has been made, in case of the death, or if it is a question of the dependence, if it is a question of the disablement, either it is a total disablement or the partial disablement, or the occupational disease has been given. So, we are having the role of the commissioner for the Employee Compensation Act has been given. So, here this commissioner would be taking up the matter, and we are having the other authorities who are appointing by the central government as well as the state government to deciding the claims. And a presiding officer of any labor court or the industrial tribunal constituted under the Industrial Dispute Act 1947 or under any corresponding law relating to the investigation and the settlement of the industrial dispute in force into that state, or any other officer with experience as a judge of a civil court or a judicial magistrate as the authority to hear and decide for the specified area all the claims arising out of the deductions from the wages or the delay in the payment of the wages of the persons employed or paid in that area, including all the matters incidental to such claims. So, we are having, if we are talking about Industrial Dispute Act, into which we are having the labor court, we are having the tribunals. They can take up the matter, they are the authority, and when we are talking about the civil court or the judicial court, they are also competent to take the matter and to decide it. Now the question comes, this authority, they would be deciding the claims, but who can file the claims? So, we are having that is a list is there. So, if the payment of the wages is delayed beyond the due date or deductions are made from the wages contrary to the proportion of this act, an application for the recovery, the same either by they can go for the application, that is the employee concerned, legal practitioner, any official of a registered trade union duly authorized in writing by the employee, or inspector or any other person with the permission of the authority hearing the claim. So, these persons, they can file an application. Sometime the employee concerned employee himself or the legal practitioner on the behalf of the employee, or if the person is attached with any of the trade union can take up the matter, or inspector or any other person with the permission of the authority, they can go for the application. Now, the important, again a very important point is the time limit for disposal of the claim. The time limit for disposal of the claim is 3 months from the date of the registration of the claim, and because the time limit has been given, that is they won't be unnecessary, they won't be extending the matter unnecessary, they won't be making the delay, because the purpose of the act is to avoid the kind of the delay should not to be there in terms of the wages. So, they have to decide the matter within this stipulated time, within a 3 months, but if both the party they are okay, employer and the employee, they are okay with that, they can go for the agreement and they can accordingly, mutually they can decide the date for the period can be extended. Penalties: if the wages are not being paid on time, unjustified deductions, excessive justifications for the incompletion of the obligations, excessive justifications for injury or the business collapse, reasoning in excess for the setting of a house rent out of the generosity or administrative power. So, we are having the provisions for the penalty, and if the wages if the wages are not being paid on time, so the person would be responsible. If there is unjustified deductions has been made, that is not the lawful deductions, the person is because of the unreasonable reason they are making the unlawful deductions, then the penalty can be imposed upon the person. Excessive justification for the incompletion of the obligations, if the employer is taking the unreasonable justification, that is why the person is saying due to this the COVID, I was not in a position to make the the wages on time, or if the person is saying that is excessive justification for injury or the business collapse, if the person is saying I am not in a position, my business is going to be collapsed, I cannot give the wages on time to my workers. So, these are not the reasonable grounds, because otherwise how this these workers they would be managing their home, and how they would be taking care of their how they will sustain. So, reasoning in excess of the setting of the house rent out of the generosity or the administrative power, because the person thinks yes, if the person is employer is not following any housing rule or not, they are not going by any kind of the rules, and they are charging, instead of paying the 3,000, they are taking the 3,500 from the workers. So, the person can be held accountable for all this. And penalty, when we are talking about Penalty include a fine that won't be less than the rupees 1,000 but could reach up to the 7,500 for these grounds. If the employer is going for these kind of the practices, the person would be penalized, and the limit will not be less than the 1,000 and up to the 7,500 it can be extended for these reasons. And in the unlikely event that the wage period is longer than 1 month, if the employer is not making the timely payment to the workers, because this is the duty to make the timely payment, then again the employer can be held accountable and penalty can be imposed. So, the grounds are the failure to pay the salaries on business day, as we discussed, that is, it should not to be any holiday, it should not to be any off day, because it has to be working day. If the person is not making the payment on a working day, the employer can be held accountable. No current currency, money notes, or both are used to pay. If the person is not using any currency notes, say if the person wants to give the that is the wages, they want to give the wages in kinds, they are not, if the employer is not paying the currency notes, then or into the coins, the person can be held accountable. Inability to maintain a record of the employee, penalty is collected, because as we discussed earlier, this is the duty of the employer to maintain the record, because he must have to facilitate the inspector if the inspector wants to say it. So, into this record, what this employer would be doing, he must have to maintain the record how much penalties has been collected. So, he has to maintain that kind of the record into that register. If the person is not maintaining that record, he can be penalized. And inappropriate use of the fine that was collected from the employees, because this was the spirit of this act, because the Royal Commission has given the recommendation whatsoever the amount would be collected in terms of the the fines. So, this kind of the fine has to be utilized for the welfare of the workers. So, if they are utilizing this fund for the other for their the personal enjoyment or for the other reason which is not justified, then the penalty can be imposed upon the this employer. The employee does not display the edited compositions of the notification of this act, and if they are not showing anything, any detail they are not displaying, then again the employer would be held responsible, and rules made punishable with a fine up to rupees 3,000. So, for these kind of the grounds, the employer would be held accountable and he can be held responsible up to the payment of 3,000. Section 16, it talks about single application in respect of the claims from the unpaid group, because a single application, if we are having the group of persons and those who want to claim, then only the one application, single application may be presented, and that can be on behalf of the other other employed persons belonging to the same unpaid group. So, one application would be enough. The authority may deal with any number of the separate pending applications presented under section 15 in respect of the persons belonging to the same unpaid group. As a single application presented under this section, that is, it can be entertained. Section 17 is talking about appeal. An appeal against an order dismissing either wholly or in part an application made under this section 15 or against the directions which has been made may be preferred within a 30 days of the date on which the order or the direction was made in the presidency town before the court of the small clause and elsewhere before the district court. So, when we are talking about that is the appeal in section 17, the time period for the appeal is given, that is a 30 days, because they want to dispose of the this kind of the speedy disposal of the matter is the intention. So, for the appeal, if any of the party is not okay with the decision which has been decided, that is, they can go for the appeal, but the time period, the limitation period for the appeal is a 30 days. No appeal can be made unless the memorandum of appeal is accompanied by a certificate by the authority to the effect that appellant has deposited the amount payable under the direction appealed against. So, if someone wants to go for the appeal, they must have to pay the amount, the court fee normally. They must have to take the certificate by the authority if they want to go for the appeal, and after making that, after depositing that amount, then they can go for the appeal. Section 17A, it talks about conditional attachment of the property of the employer or other person responsible for the payment of the wages. Yes, because this is very, very important when we talk about, sometime if they are having the apprehension, that is, this employer is going to evade the order of the court, or they are not going to follow the order, then in that case, the property of the employer or any other person who is responsible on behalf of the employer, the property can be attached for that matter. Section 18 is talking about powers of authorities appointed under Section 15. Every authority appointed under this Section 15 shall have all the powers of the civil code under the Code of the Civil Procedure for the purpose of taking the evidence and for enforcing the attendance of the witnesses and compelling the production of the documents, and every such authority shall deem to be the civil code of all the purposes of Section 195 and under the Code of the Criminal Procedure. Section 22 is talking about bar of suits. No court shall entertain any suit for the recovery of the wages or for any deduction from the wages insofar as some so claimed form the subject of the application under Section 15 which has been presented by the plaintiff and which is pending before the authority appointed under that section or an appeal under Section 17 has formed the subject of the direction under Section 15 in favor of the plaintiff or been adjudged in any proceeding under Section 15 not to owe to the plaintiff could have recovered by the application under Section 15. So, bar of suit arises, Section 22 is saying bar of suit arises if the matter is already before the authority, if any kind of the decision has been given by the authority, if any kind of the decision which has been decided into the favor of the plaintiff, or these kind of the genuine reasons if they are having, then in that case they cannot allow to go. That's why the bar of suit is there, because already the matter is going on, then that's why we are having the system for the bar of suit. Section 24 is talking about delegation of powers. Appropriate government may by notification in an official gazette direct that any power exercisable by it under this act shall in relation to such a matter and the subject to such a condition, if any, as may be specified in that direction, be also exercisable, where the appropriate government is the central government by such officer or the authority subordinate to the central government, or by the state government by such officer or the authority subordinate to the state government as specified into the notification, where the appropriate government is the state government by such officer or the authority which are subordinate. So, when we are talking about delegation of the powers delegation of the power comes if it is the appropriate government is the central government, they can delegate this power who is a subordinate into that subordinate authority, they can delegate. Same is the case with the state government. State government can delegate the power to the subordinate officer. Protection of the action taken in good faith. Under Section 22A of the Act, no suit, prosecution or the other legal proceeding shall lie against the government or any other officer of the government for anything which is in good faith done or intended to be done under this Act. Section 23 is talking about the contracting out. If there is any contract or the agreement made before or after the commencement of this Act, whereby any employed persons relinquishes any right conferred by this Act, shall be null and void insofar as it purports to deprive him from such a right. If the employer is entering into the contract in such a way by which it has been mentioned that is, employee himself wants to waive the right, want to relinquish his right, he is okay with it, what has been mentioned into the agreement. So, this kind of the unfair agreement considered to be the null and the void. So, the employer cannot draft these kind of the agreements points into their favor. And display by the notice of the abstract of the act, it is very important that this is the responsibility of the employer. They must have to make the abstract of this act by which the majority of the person they can understand, the employee or the worker they can understand, and they must have to draft in such a language by which majority of the worker they can understand the language, because for which otherwise what will happen if it is if they are saying this kind of the act is amounts to the omission, so the person will not, they will not understand. That's why they must have to display it on their special boards or on a notice where the majority of the worker they can read it. And payment of the undisturbed wages in case of the death of the employed person. So we are having the provision here in section 25A. If they are having the undisbursed wages, so we are having the provision they can do it if the death has been caused to the employee. And in section 26, the appropriate government is having the power to make the rules relating to it. So if they feel so there is a need to add something, so they can add it. So and they want to change something, they can do so. So this is the power has been given to the appropriate government. So this is from my side. Thank you so much.
I am A.K. Sharma and I am Professor of Sociology at IIT Kanpur. The question I am going to address is what is urbanization? Urbanization is essentially the process of population concentration, which means that if more people start living in a smaller number of places, or if the distribution of population becomes more unequal, like more people living in places like Bombay, Calcutta, Mexico, then we say that the urbanization is taking place. Essentially it means increase in percentage of population living in areas or localities which are defined as urban. Urbanization is a new phenomenon, of course, a post-industrial phenomenon. About 200 years ago, hardly 5% population of the world lived in urban areas, and today more than 50% population of the world is living in urban areas or localities which are classified as urban. You will be happy to know that according to 2011 census of India, in our own country for the first time, increase in the urban population has been greater than the increase in the rural population. Though India is not so urban as the developed countries, and about 31% population of India only is living in urban areas. We can believe that in 10 years, 20 years, 30 years time, India will also be more urban, at least more urban than what it is. It may not be 80%, but certainly it will be 35% or 40%. Now, how is this urban locality defined? Because this definition of locality as urban or rural is crucial to measure level of urbanization. I will give you definition of our own country. In Indian census, an urban locality is defined in two ways. There are statutory towns and there are census towns. All places with municipality, municipal corporation, cantonment or notified town area committees are called urban. This is statutory definition. According to demographic definition, there are three main criteria. If a locality has more than 5,000 people, or 75% of male labor force is engaged in non-agricultural activities, or the density of population is 400 per square kilometer or 1000 per square mile, then we say that the locality may be classified as urban. There are many other additions to this definition. Now, we have the concept of urban agglomeration and many other things, but essentially this is how urban population is defined in India. And as I said that urbanization is associated with economic development and industrialization, same is the case with India. About 100 years ago in India, only 11% people were living in urban areas. Today 31% are living in urban areas, and this is obviously linked with economic development of the country, growth of per capita income and industrialization. I remember that in one 5-year plan it was mentioned that today this urban population can grow by way of natural increase of births minus deaths in the urban areas itself, or through rural to urban migration. Today nearly 60% contribution to growth of urban population is due to rural to urban migration, and this is going to increase. This is essentially what urbanization means. Urbanization means growth of population in localities defined as urban in relation to population of localities defined as rural, and I have given you Indian definition. Thank you very much.